Levante Shannon.
Yes, sir. Can you hear me?
Alexander on behalf of the people.
Right from the opening seconds, the tone feels deceptively calm, but underneath that polite exchange is a case that's already carrying serious weight. We're dealing with a defendant who's clearly trying to present himself as cooperative, respectful, even grateful. But in courtroom dynamics, that surface-level politeness doesn't erase the underlying legal reality. And that reality, it's an OWI third offense situation with prior history, which immediately raises the stakes. Judges don't just look at how you act today. They look at patterns, history, and compliance over time. That's what's going to define everything moving forward in this hearing. What's also critical here is how early impressions can shape judicial perception. A simple "thank you" might sound harmless, but if it's followed by inconsistencies or violations, it quickly loses credibility. This case is setting up to be less about politeness and more about accountability. And as you'll see, that tension between what's being said and what's actually happening is about to explode into the central conflict of this entire hearing.
Can you hear me? Can everybody hear me?
Assistant
Yes.
Public Defender Hannah Apple appearing on behalf of Mr. Shannon. Mr. Shannon, will you state your name for the record?
Levante Shannon, Levante Cedric Shannon.
Okay. What are we doing today?
Your Honor, today's date and time, we are asking for an adjournment. Mr. Shannon has completed an inpatient treatment recently, so I'm asking for documentation from him so that we can further discuss negotiation with the prosecutor's office.
And Your Honor, before we set a date, I did want to make the court aware that he's had multiple missed tests as well as positive tests from August 12th until September 10th, which is very concerning to the people given that this is an OWI third in which the BAC was 0.188 and he's had numerous previous OWIs.
And also, just so that you know, he's probably going to repeat what he put in the chat, which he probably shouldn't have put in the chat.
I saw that, Your Honor.
Yeah.
Can I say one thing?
I saw
I
the
didn't-
distress on your face.
Yeah,
Did you
Mr.
tell him?
Shannon?
I had no idea because the scrambler, it was non-alcoholic beer. That's what it said, non-alcoholic. So I'm on naltrexone. I can't, this right here is a blocker. You can't get drunk on it. So I was just drinking for the taste of beer. I was, we were barbecuing and things like of that nature. And I was just only drinking for the taste of beer.
Your Honor, if I
Yeah.
may,
you might want to jump in here, Miss Apple.
yes, Your Honor. So the information that Mr. Shannon did put in the chat, Your Honor, I would ask for some consideration considering this confusion on it. Mr. Shannon.
Confusion on what?
This is where the defense begins laying the groundwork for mitigation, trying to reframe the situation as confusion rather than intentional misconduct. That's a very strategic move. In legal terms, intent matters. If the defendant knowingly violated bond conditions, the consequences are far more severe than if there was genuine misunderstanding. But here's the problem. The explanation being offered, confusion over non-alcoholic beer, immediately raises skepticism. Courts are extremely strict when it comes to alcohol monitoring conditions, especially in repeat OWI cases. The expectation is not just compliance, but hyper-awareness. When you're under court supervision, "I didn't know" becomes a very weak defense, and you can already feel the judge starting to weigh that explanation against the objective data, test results, prior violations, and behavioral patterns. This is the moment where the case pivots from a procedural discussion into a credibility battle. And once credibility is questioned in court, it becomes incredibly difficult to recover. Everything the defendant says from this point forward will be scrutinized through that lens.
I didn't know that non-alcoholic beer contained alcohol because I was on the scrambler and it never came up.
Mr. Shannon.
Huh?
Your Honor, it would be concerning as when he did test positive, he was at a 0.027, 0.021, 0.020, 0.016, and so on.
If the court would allow Mr. Shannon one final opportunity, he would report for a
To
scram
do what?
tether
Drink?
No,
to
I'm
not to
done.
prove to the court
I
that
threw it all out.
Your Honor, I request on behalf of my client one final opportunity now that it is very clear that he is not to consume even non-alcoholic beer as there may be alcohol in it and be placed on a scram tether. and that I can get the documentation regarding the treatment program. He did inform me that he completed a 30-day in treatment at Brighton Recovery Center and provide that to the court and to the prosecution.
Oh, I need a copy of the report because I don't have the report from community correction. This is one of those times that maybe if the client hadn't started talking, you'd get your wish, Miss Apple, but I don't think so. So what I'm going to do is I'm going to pass the matter. Can prosecutor or the public defender send to Miss Weidling a copy of his report, and then I'll call his case back up. We'll deal with this bond issue in the adjournment. For the past. Court calls the case, People versus Tamara Shukai.
Maria Sinski on behalf of the people.
And Assistant Public Defender Emily New on behalf of Tamara Shukate. And Ms.
Ms.
Shukate,
Shukai, she's not here.
This moment highlights something critical about courtroom expectations. Attendance is not optional. When a defendant fails to appear, especially without prior notice, it immediately signals risk to the court. And risk is what judges are trained to control. The defense is asking for leniency, just 72 hours. But from the judge's perspective, the question isn't about kindness, it's about reliability. If someone doesn't show up today, what guarantees do they have for tomorrow? That's why you see such a sharp response. Bench warrants aren't just punishments, they're tools to enforce compliance. And notice how quickly the judge escalates from a discussion to a financial consequence. $10,000, then increased further. That's the system reacting in real time to perceived risk. This isn't emotional, it's calculated. The court is essentially saying, if you won't show up voluntarily, we'll make sure there's a strong incentive or consequence to ensure you do next time. And that same logic is about to be applied even more aggressively when the focus shifts back to Shannon.
And Your
Bench
Honor,
warrant will go ahead.
would you consider holding off for 72 hours since this is the first PCC and I don't see that she's missed before?
Okay, so why would I do that? Oh,
Since
because
she
she
hasn't-
hasn't missed before and it's the first one? No. 10,000, bench warrant, 10,000, cash surety. That warrant will issue immediately. And it worries me because of the nature of the charge, what's going on.
Your Honor,
Thank you.
Your Honor, I did want to mention
Yes,
that the defendant there was a community corrections report from September 8th where the defendant blew a .096 at 9:35 a.m. on September 7th and then proceeded to miss the rest of the test that day and miss the test the next day.
so she blew numbers on the 7th. I don't have that report either.
Yes, she blew a .096 at 9:35.
Okay, that, I knew that's part of my concern when somebody doesn't show up, but. So
Understood.
the bench warrant amount will change to $25,000 cash surety issued immediately, given that. All right, thank you.
Thank you.
Court calls case, People versus D'Angelo Simmons. Oh, it's right there. Okay. Court recalls the case, People versus Levante Shannon.
Ally Zund on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Shannon. Mr. Shannon, will you state your name again for the record?
You're muted,
You're muted.
Mr. Shannon.
Are you able to unmute your device, Mr. Shannon? You're still muted.
Am I unmuted?
There you are. Please state your name.
Levotny Cedric Shannon.
Now the focus returns directly to Shannon, and this is where things start tightening significantly. The judge isn't just asking routine questions anymore. He's reviewing a bond violation report. That's critical. A bond violation report is essentially a documented pattern of non-compliance. It's not one mistake, it's a timeline. And timelines in court are powerful because they remove ambiguity. They show behavior over days, weeks, sometimes months. What the judge is about to do is walk through that timeline piece by piece, building a narrative that either supports or destroys the defendant's credibility. And here's the key tension. Shannon is still relying on the non-alcoholic beer explanation, but the data the judge is about to present may not align with that claim. This is where many defendants make a critical mistake. They underestimate how closely judges analyze patterns. One inconsistency might be explainable. Multiple inconsistencies? That becomes a credibility collapse. And once that happens, the court shifts from questioning to concluding.
I'm looking at this bond violation report, and my concern is I don't have a report before this one, I don't think. It rained on 8/8. Yeah, because he was arraigned on 8/8. This is really the first violation report. And from August through now, well, because he didn't appear on August 17th. Well, we didn't get the report, but here's my problem with what I'm seeing here. On August 12th, after his arraignment, he gets to an 026, then misses his scheduled retest on that August 12th day. We go 2 days later. Well, on August 14th, he blows a 0.066. Then it slowly goes down, so he then blows a 6.7, a 3.7, 0.37, and that's on the 14th. Then don't really have any incidents, although no, we do. Then on the 14th, he finally got down to an 0.4, but that actually went up on that day. Then that's on the 14th. Then we come down to September 8th, and he's missing other tests, but his makeup tests are showing negative. But then we get to September 8th, when he blows an 0.21, an 0.20, and a 0.16. Then on the 10th, he blows an 0.41.
At this point, the judge is systematically dismantling the defense narrative using raw data. Every number he's reading out, every test result is building a contradiction. This isn't random. This is deliberate judicial analysis. The pattern being described doesn't align with occasional or accidental exposure to alcohol. It suggests repeated consumption. And that's the problem. Courts rely heavily on consistency between explanation and evidence. When those two don't match, the explanation collapses. What makes this moment so critical is that the judge isn't reacting emotionally. He's reasoning out loud. He's showing exactly how he's arriving at his conclusion. And that transparency makes it even more difficult for the defense to counter. Because now it's not just about arguing. It's about disproving a logical sequence that's already been laid out in front of everyone. This is where the case begins to shift from defense opportunity to judicial skepticism.
And then subsequent tests for alcohol thereafter showing that. And then later on the 10th, he missed a scheduled retest, but then later on the 10th, he's blowing numbers. Now, am I to understand that all of that is from Bud Zero? Is that the defendant? Hold it. Whoa. And Mr. Shannon, let me just tell you, been doing this a long time. So you might want to think before you start answering me.
Okay.
Am I to understand that all of that's from Bud Zero?
Some of it's from O'Doul's, but zero. I drink Heineken zero, but I'm on naltrexone. So even if I was drinking alcoholic beverages, it wouldn't, you know what I mean? So it would defeat the purpose. I was just drinking because I'm around people that drink.
I didn't ask you all that.
Yeah. Well, yes, it is.
And you're saying it's from O'Doul's, Bud Zero, and what else?
And what O'Doul's, sometimes it's Heineken zeros. I drink a ton of them. And I didn't know because when I was on the scrambler, it never appeared. It never showed dirty. It never showed dirty. It only shows dirty on this machine. This machine is super sensitive. I didn't know it. I didn't understand the technology.
This is a turning point, and a dangerous one for the defendant. Claiming a lack of understanding about the technology might seem like a fallback explanation, but in a courtroom, especially in cases involving monitoring devices, that argument rarely holds. Why? Because compliance conditions come with an expectation of responsibility. If you're placed on a monitoring system, it's your obligation to understand its rules. The court doesn't see ignorance as an excuse. It sees it as negligence. And notice how the judge responds, not by debating the technology, but by focusing on behavior. That's key. Judges don't get distracted by technical explanations when the behavioral pattern is clear. And at this moment, Shannon is talking more, and that's actually hurting him. Over-explaining in court can quickly turn into self-incrimination, especially when it introduces inconsistencies. This is where many defendants unintentionally escalate their situation by trying to talk their way out instead of recognizing when to stop.
Mr. Shannon,
Yes, sir. Yes, sir, Your Honor.
you blew an 06, a .06.
Yeah, and I looked it up on the website when after I talked to my attorney, Miss Apple. I looked it up.
Okay, so
And-
Mr. Shannon,
Yeah.
I'm gonna stop you right now because you already may have talked yourself into jail, but you're not helping yourself
Okay.
at all.
Okay.
But I'm going to give you an opportunity at least to speak with your client. I'm going to adjourn this matter to our 3:00 block with the bond hearings. I might suggest to you that between now and then that you get whatever affairs you need to get in order.
Okay.
The first thing you probably ought to get in order, and you can have that conversation with Ms. Apple, is you might want to get your story in order to me. I don't, I realize people mess up. I get
Yes,
it.
sir.
But the thing I hate more than that is when people lie to me.
I understand that.
I'm just going to leave it right there. We'll see you at 3:00.
This adjournment might seem like a pause, but it's actually a strategic reset by the court. The judge is essentially giving the defense one final window to regroup, reassess, and potentially correct the narrative. But make no mistake, this is not a sign of leniency. It's a controlled delay. The judge has already expressed concern about honesty, and that's one of the most critical factors in any courtroom proceeding. When a judge explicitly mentions lying, that's a serious red flag. It means trust has already been compromised. And in legal proceedings, once trust is gone, everything becomes harder. Arguments, negotiations, even sentencing outcomes. So this break isn't a relief. It's pressure. The defense now has to decide. Do they stick with the current explanation, or do they adjust strategy entirely? Because whatever comes next will likely determine the direction of the case.
Yes, sir.
Thank you.
Your Honor, to clarify, is that in person at 3:00 or is that via Zoom?
Hang on a second. We had a kid, but we'd like him in person.
Understood. Thank you.
Thank you.
I gotta find the bus schedule. I'm
All
Mr.
right.
Apple,
Well, you
I gotta find a way to get there. I
sounds
don't
right
have a way.
past. Well, we can provide transportation if you have a problem. I don't think you want us to do that.
Huh?
Nothing.
Mr.
All
Shannon, you
right.
can call her
Thank
off.
you. We'll
Thank you.
see. That's it for that block. Okay, court stands in recess. We'll be back at the top of the hour, October 5th,
Thank you, Your Honor.
2023, 9 a.m. Bond continued. All right.
Thank you, Your Honor. Have a
Thank
great
you.
day, everyone.
All right. Thank you, Mr. Williams.
What do you want to do first? You want to do the add-on or you want to do the leave withdraw?
Let's do the court does call the case of the people of the state of Michigan versus Shannon, Levante Shannon.
Ally Zend on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Shannon. Mr. Shannon, can you state your name for the record?
Labotny Shannon, can you hear me?
Yes, I can hear you.
Okay.
All right, this was originally set and I had indicated that Mr. Shannon needed to come in person, but I think there may have been some transportation issues, which he won't have until 4:30, at least we are informed. So I've allowed him to appear for the purposes of this hearing via Zoom.
Okay.
All right. So oh, go ahead. I'm sorry, Miss Apple.
No, Your Honor, I didn't apologize for interrupting, but I want to thank the court for allowing that. Mr. Shannon is currently in Detroit, so he informed me that he would not have transportation until 4:30 today. So I do appreciate the court's courtesy in that. I did have an opportunity to speak to Mr. Shannon after the previous court hearing and was able to get some additional information from him. He would admit today to the violation. He informed me that he was consuming 20 to 30 beers a day of the O'Douls, which contain 0.5% ABV. And so he would admit to consuming that alcohol and understands that that is a violation of his bond, which resulted in multiple positive tests at this time.
Now this is a major shift. The defense is moving from denial to admission, and that's significant. Admitting to a violation can sometimes be a strategic decision, especially when the evidence is overwhelming. It allows the defense to pivot from arguing facts to negotiating consequences. But here's the issue. The explanation tied to that admission still doesn't fully align with the data. Consuming 20 to 30 non-alcoholic beers daily raises serious questions, both practically and physiologically. And the judge is already thinking ahead. He's not just evaluating the admission, he's evaluating whether the explanation makes sense. Because in court, partial truth can be just as damaging as a lie. The defense is trying to regain credibility, but credibility isn't just about admitting fault. It's about consistency, logic, and believability. And right now, that's still in question.
Okay, I get that. Let me just say this, because it is about a 10 to 12 can ratio of the non-alcoholic to the alcoholic beer. Problem with that whole analysis is, while he may have been consuming that amount, and I'm not going to go into great detail on this, because of the elimination rate of a human being, for him to get to that level, he would have had to consume those 10 to 12 in the time it would have taken to do one beer. Yeah, I don't think that happened. That's a lot. But I'll accept the admission to the violation. While I still don't believe what he's indicating in terms of how that happened, but I'll accept the admission to the violation. Did we set a new date on this yet? No. What I will do is well, Ms. Apple, what were the parties intending on doing with this case?
Your Honor, I was seeking an adjournment to get some documentation of treatment that Mr. Shannon completed in discussion of potential resolution or waiving this matter to circuit court.
All right. Well, Mr. Shannon, anything you want to do before I sentence you on the violation?
No, sir. Just that if I get sentenced to some time, I would turn myself in Monday or Sunday night to the county jail.
Well, I'm going to order that the defendant, before I sentence him on the violation, the defendant year to surrender to the Washtenaw County Jail by 6 p.m. this evening.
This is the consequence phase, and it's decisive. The judge is no longer evaluating possibilities. He's issuing orders. Surrender to jail by 6 p.m. is not a suggestion. It's a direct command. And what's important here is the conditional structure: comply or face a no-bond warrant. That's a serious escalation. It removes flexibility entirely. This moment reflects the court's final assessment of risk and credibility. And clearly, the judge has determined that stricter control is necessary. What's also telling is how quickly the judge shuts down attempts to negotiate timing. That indicates a loss of patience. In courtroom dynamics, once a judge reaches that point, the window for leniency is effectively closed. The system has moved from evaluation to enforcement.
Or a bench warrant will issue for your arrest with no bond.
Okay. Would it be okay with you if I did it Sunday night though? Because I just got one
No,
thing
sir. No, Mr. Shannon, I
got
don't
one
have a
very-
problem giving people some leeway.
And that's what I'm
but-
asking for. I got something really important I gotta do tomorrow. And I
Mr.
can
Shannon,
turn-
I'm gonna advise you to let the judge finish his direction.
I don't mind, and I'll just say this, Mr. Shannon. I told you that I get people that they slip up. I get that things happen. And I'll be able to deal with people when that does. But
Mhm.
what I don't like is when something happens and people are lying to me. I think you were lying to me when you were first here. I
Yeah.
think that then through your counsel, but I mean, I understand she's advocating for you.
Mhm.
I don't think you're telling the whole truth in terms of your consumption of alcohol. You could not put 20 to 30 beers in the time it takes for one beer to get into your system because your body can't hold it. And then you're going to be eliminating that alcohol that you're putting in. It doesn't make any sense.
Mr. Simpson. I
You can
think-
shake your head all you want. You're
I
lying
think-
to me. You're shading
I'm
the
not-
truth. 6
Okay, well,
p.m. today. Do you understand me? I'm done talking to you. Or a bench warrant will issue without bond. Miss Apple, would you like me to then set this for next week or 2 weeks out?
Your Honor, if it could be set for next week, please. Thank you.
Next week, I'll set probable cause conference September 21st, 2023, 9 a.m. Thank you.
This final moment captures the complete breakdown of trust between the court and the defendant. The judge isn't just frustrated, he's reached a conclusion, and that conclusion is centered on credibility. Throughout this case, the core issue wasn't just the violation, it was the explanation. The repeated inconsistencies, the shifting narrative, and the implausible claims all led to this outcome. Judge Simpson made it clear, mistakes can be tolerated, but dishonesty cannot. And that distinction defined the entire ruling. The order to surrender, the refusal to negotiate further, and the strict enforcement all stem from that loss of trust. The key takeaway here is simple. Compliance is critical, but credibility is everything. Once the court believes you're not being truthful, every opportunity narrows. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.